Ready for State versus Cole. Ms. Newell.
May it please the court, counsel. My name is Ella Newell, and I am here on behalf of the appellant Paula Lynn Cole. This is a case about whether a mother who leaves her 12-year-old in charge of his siblings while she goes to the store to pick up toilet paper and diapers constitutes child endangerment under Iowa law. Ms. Cole asks that you vacate the judgment of the lower court and remand the proceedings for an entry of dismissal. In order to establish a claim of child endangerment under Iowa law, the state must prove that a defendant knowingly engaged in conduct which caused a substantial risk of mental, emotional, or physical harm to a child. Knowingly refers to creating the substantial risk and not simply the act of creating the risk. Child endangerment is a general intent crime which provides that the prohibited result must be reasonably expected to follow from the circumstances presented. In other terms, a nexus. A substantial risk must be a real and articulable harm to a child's physical, mental, or emotional health or safety.
The facts, and you can correct me if I'm wrong. I saw that a CPW testified about an investigation and a report, but there's no report in evidence that I can see. There's no word, the magic word founded, I never heard or read. Was there a child abuse assessment? And if so, what is it a part of the record? I'm lost.
I believe that there was an assessment done, but it was not part of the record. It was not provided to the jury. I'm not clear on whether it was founded or unfounded. And so because it's not in the record, any additional information about that would be speculative. But I believe that it was only used for impeachment for the DHS worker about a couple of facts. In order for an individual to be convicted of child endangerment, the state needs to demonstrate that there was a reason to expect that that something unusual would happen. Under these facts, Ms. Cole had left her 12-year-old son in charge of watching his siblings on a previous occasion. Nothing bad had happened. There's no evidence in the record that anything like what happened on July 2nd, 2021 occurred at any point previously. There was no reason for her to expect that her son wouldn't be able to successfully watch his siblings on that day. Because no evidence was presented by the state on the particularized issues that would be needed in order to establish that the prohibited result was reasonably expected to follow, their claim fails. Case law on this point, cases on child endangerment typically involve some kind of illegal conduct.
Thanks for pausing, first of all. My question is whether we should be interpreting the statute based on our cases, or whether, since this is a substantial evidence review, shouldn't we be focusing on what the jury instructions said? I don't think there were any objections to the marshalling instruction.
And the jury instructions are fairly analogous to Iowa law. I think that there's some slight deviation, such as a child under the age of 14, or the word nexus isn't explicitly used within that context, but even focusing on the jury instructions, there was not sufficient evidence. At trial, the state repeatedly said that the risk was that a bad thing could happen and that the child in charge could not prevent bad things from happening. Parents can do everything right and bad things can still happen to children. There's no foundation under Iowa case law or Iowa statutory law that provides that parents have to prevent bad things from happening. For example, in State v. Smith, there were 2 adults at home. A DHS worker had helped clean the house the previous day, but a 5-year-old child still stumbled upon rubbing alcohol and drank it. Under those facts, the Iowa Supreme Court or Iowa Court of Appeals found that there was not child endangerment. There are risks that a child could be exposed to by staying at home versus going to the store with a parent. And so any decision that a parent makes is subject to different risks that another decision wouldn't necessarily be subject to. Ms. Cole.
I hesitate to do this, Ms. Newell, but what would your view be as to the the minimum age of the oldest child that you could, if you wanted to leave your children, take the infant and go to the store?
I'm going to give the classic law school answer and say it depends. I don't think that there's a real age that any.
For the jury?
I think in some way, I mean, in many ways, yes, it is for the jury, but this is also a case where the court can step in and say there weren't sufficient facts alleged in order to provide a sufficient claim for child endangerment, that there were several background facts missing, that typically with a child endangerment case, there are significant background facts that are alleged under these facts. Had the state presented evidence such as the 12-year-old routinely fell asleep or the children routinely got into fights, that would create a rise for child endangerment. But because Ms. Cole had left her children home alone with the 12-year-old watching and nothing bad had previously happened, it was reasonable for her to act similarly under these circumstances. I know that that doesn't quite answer your question, but I don't believe that the court needs to allege a specific age that a child can be left home alone. The Iowa legislature hasn't done it. I don't believe that the court needs to step in to create a certain age at which children can be left home alone, or at which.
State-approved babysitting course that has a recommended or minimum age?
Sure about state resources, but the American Red Cross provides babysitting classes for children who are 11 years old.
Extension do that too?
Sure, but if I'm willing to be corrected if that is the case.
History of abductions in that neighborhood?
No, not that that was presented, not that I could find. The risk of abduction is inherently imaginary. There was a law review article that I cited that explains that those risks are virtually zero. It's because there wasn't any additional evidence to say that there was a murderer on the loose or there was someone who was abducting children on the loose. That evidence is inherently speculative and conjecture.
A summer day. What about the risk of the 8-year-old wandering off into traffic or somewhere else?
There's no evidence about whether or not there was a busy traffic street. The evidence was somewhat conflicting on how far she left, if she went into the parking lot, if she stayed near the stoop of the apartment. If the court would like to take judicial review of the Google Maps that shows it's not near a busy road, at least with that entrance to the parking lot.
Jury have inferred from the fact that she made up a story about, I think, the children's father watching them, that was evidence that the mother knew that she shouldn't have left the children home alone?
Ms. Cole did not. I don't believe that the evidence shows that she made up a story about the father coming home. Her exact words were that she was planning on leaving. She did leave the children home alone for a brief period of time. She ran into their father in the parking lot, knowing that they would be left alone inside the house for a brief period, and gave him some money to go to the store, to the gas station. That information doesn't necessarily rise to the level of the knowledge that would be required to create a substantial risk. Had any of Ms. Cole's statements, for example, said, I shouldn't have left the children alone because they always get into fights, or something along those lines, that would give rise to knowledge, but simply saying and trying to explain that the father was maybe or maybe not supposed to watch the children at that time, I don't believe rises to the level of an inconsistent statement. There was evidence that the children had a phone, that they knew how to use it. They were able to call 911. They had a plan in place where if something were to happen, they had an open door policy with their neighbors. Mr. Wheeler testified that there was no need for Ms. Cole to notify him if she was going to be leaving, him or his wife, that the kids could come over. There was also no evidence that they ever needed to use that backup plan, but that was in place as a precaution. Ms. Cole made a reasonable and normal parenting decision that parents across the state of Iowa make every single day. When she left to go to the store, it was in the middle of the day. It was to run a quick and necessary errand for toilet paper and diapers. And in Exhibit A, you can see that she's coming into the house with a baby with, I believe, a 12-pack of toilet paper and 2 containers of diapers. Three of the kids appeared to be sleeping. Two of the kids she woke two of her oldest children up to watch the siblings, which she had done before. The kids had a cell phone, they knew how to use it. No one was arguing or upset when she left, and her actions were reasonable.
More of a free range philosophy of parenting, and you said normal parenting decision. Isn't the jury the conscience of the community to decide whether what she did was reasonable?
I believe that this is where the court does need to intervene on this point, that while the jury is responsible for weighing the credibility of evidence and looking at the facts to see if they apply to the law, the sufficiency of evidence review standards allows the court to come in and make sure that the facts presented actually meet the legal requirements for child endangerment. So I believe under these facts, you could find that there was not sufficient evidence and then vacate the decision from there. And I will return on rebuttal. Thank you.
Get started. Help me understand how this case is not a discussion about a paper cut. To help me understand where's the substantial risk? And I think you probably know from some of my earlier questions where I'm going with CPW and some of those things. Where is the substantial risk that anyone in the court system, we know it when we see it? Where?
So the substantial risk begins from the ordinary substantial risks that are present when children of a certain age are left unsupervised and without access to a phone that they would need to contact emergency services. There are
Age. There's nothing out there. There's babysitting courses. My 8-year-old daughter, who's now 30, I would have put her in charge of her 13-year-old brother until the cows come home. And that would have been a wise decision. So age, unless you can point me to something that talks about age, we're not talking about age, so then you'll have to talk about evidence of where this age was inappropriate.
particularly about the younger children. When you start talking about the older children and their fitness to supervise, that, and based on your experience, that's based on a knowledge of the characteristics of the children, their abilities, their temperament, the presence or absence of conflicts between the children. This is something that comes from a parent's knowledge, right? And Ms. Newell is correct. There's no minimum age threshold. It depends. It depends on the maturity of the child, the complexity of the supervision or babysitting task. Now, in this situation, first off, the 12-year-old was asleep. And the jury was free to reject any evidence that said otherwise based on the evidence that it did have showing that he was asleep the whole time and was not providing any supervision. Then we have the 10-year-old who is a child with autism that impairs social and emotional processing.
Script, would I find that? I looked pretty hard to find that it impaired his social and emotional. I mean, I understand that he had autism. That was in there. And I understand there was criticism of his discussion of the 911 talk, but he sounded pretty reasonable to me. Got a hold of 911, explained the situation. Help me with that.
So I think that on some level, you know, if you had an amputation in the record, you wouldn't need record evidence describing what an amputation is. It's a commonly understood phenomenon.
Different things, right?
Spectrum of things, but the unifying characteristic of autism is impaired social emotional processing to some degree. Now, the jury could hear the 911 call as well, and so could the trial court. And the trial court, in ruling on the motion for judgment of acquittal, said, I'm listening to this child on the call, and the child is having some difficulty giving direct answers and is having, now I think the child was conversant.
You that too, Mr. Sloven, and I mean, I listened to that call too, and I think it's the dispatcher is having more problems than the kid. The dispatcher is the one that seems to be having trouble tracking. You know, I mean, can't we, the state has some, can't just transform anytime 911 happens to be called and there's some, you know, and the cops are unhappy to have to come, into a criminal charge, right? I mean, there has to be something special about this.
That the child called 911 is something that I anticipated having to explain away, having to say, look, this child knew that he could call 911 if he had a phone. And the problem is that the evidence tends to show that Ms. Cole left the children without knowing.
Okay, you've said that a few times without a phone. when we're reviewing substantial evidence, we still have to review all of the evidence. And didn't the officer, he might have said on direct that he didn't think that there was a working phone, but then on cross-examination, didn't he admit, and you can see it in the video, that the little girl did have a phone? And didn't he admit that she's the one that gave her the mother's phone number to him?
You can't see that she has a phone. What he said was that it wasn't a working phone. Now, he does answer leading questions on cross-examination, but mostly what he says is, if that's what the video shows, then that's what happened. And that video was never shown. If the jury could infer that
Where she comes out of the bedroom.
but the testimony was that it didn't have service, it couldn't be used to contact the mother.
Matter of charging, I thought, according to the testimony.
To the testimony that the jury would be free to reject. And Justice Oxley, I think you're right that on sufficiency review, the court reviews all of the evidence, but it reviews all of the evidence through a lens of a jury could make a credibility determination that certain evidence was not credible. So I'm not saying that this court can.
Right? And how did they get hold of her other than through the daughter's phone?
Was aware of the mother. The officer's testimony is that dispatch found the number. And now I'd invite you to consider, if the phone had the number in it, then why was it necessary to have dispatch call the mother instead of the child or the officer on the scene?
Call that in the testimony. So dispatch had the number. Well, I thought the officer indicated that either he called the mother or on the phone or got the number for the mother from the phone.
Correct. The officer testifies that dispatch had to find Ms. Cole's number and that dispatch called.
The evidence shows there's a substantial risk of what?
So substantial risk of household injury. This is particularly the younger children, household injury, play, burns, cuts, injuries. If injured, a inability to seek emergency services for it. Then there's also
Instruction. It says it has to be a very real possibility. In your mind, what's the distinction between a possibility and a very real possibility?
very real possibility. I think it's deliberately not defined so that the jury can apply its collective community judgment, lived experience, common sense of which possibilities are real and which are more speculative. So it's not the risk that, it's not a risk that flies out of left field given our experience with younger children. Younger children play and they get hurt. There's also risks particular to these particular children and their conflicts. She tells the DHS worker that there's relational conflict between the siblings.
I grew up with 3 sibs, and the stuff that I read was totally normal. Now, if somebody gotten hurt, I think it's a real easy analogy to make sense that, yeah, there was a risk and it actually happened. But I am still having a really hard time, especially the state calls as a witness, the CPW. And I have never seen in my experience, when you get to the district court level, the reason the state's going to call that person is to rat them out, that there was a founded abuse report, blah, blah, blah. Never once do I see that word. I don't see a document. That's clear and convincing evidence. This is beyond a reasonable doubt. Where is the risk? Where is the actual injury? I see nothing.
First, I need to point out, we aren't allowed to present evidence of a founded report because that substitutes the finding for the jury's ultimate determination of fact.
Correct?
Believe there was an investigation. I'm not sure about the outcome. It's not in the record, and it wouldn't be useful for sufficiency anyway. What I can tell you is this. Actual injury is not the standard for substantial risk and
even threat of injury. I'm not even hearing anything where you say there was a hot iron on the floor and it was inches away from the child. Nothing.
What I can tell you is that the child who calls 911 says that the daughter was threatening or attempting to put hands on the 5-year-old because she was mad, and that he managed to stop her, and then she left. And now, when you say that nothing bad happened, I mean, that's good, and we're all very glad about that. But then she leaves barefoot from this apartment building, which there's some evidence in July, that's true, but to which she couldn't get back in without a key or a card or something. And there's
The vestibule?
neighbor, and this is on page 67 of the transcript, says that when he saw her, she was heading off of the property.
I mean, to be blunt, she's barefoot in the summer. Why is that a substantial risk of anything? What is the harm that the state is seeking to avoid?
seeking to avoid the harm of these children being left unsupervised. These children whom the mother then knows has the
Parent let a child go outside barefoot in the summer, knowingly embracing the risk of barefootedness. Is that a criminal act because there's some sort of risk of a child stepping on something outdoors?
itself. Now, it also depends on proximity to roads and
The child is barefoot. Why is that relevant in our assessment of risk?
to consider and to add in that this child doesn't.
Evidence of risk of something, and it has to be danger or physical harm, right? So what does it prove that she was barefoot? How does that increase the risk of harm to the child?
Another factor to consider about the child's development, maturity, ability to be left to her own devices, that she's going to go out into the parking lot and leave the property without shoes in the middle of Now, I don't know that this court can take judicial notice of the map. I know that jurors who live in Black Hawk County have a general familiarity with Black Hawk County, and I don't think it's correct to say that there weren't busy roads near this apartment building. I would also say that Justice McDermott, you asked a really important question, which is if there's no substantial risk being created to these children, but the officer spent 20 minutes with the children waiting, and then he gives his personal opinion that they're not sufficiently mature to be able to supervise them. So definitely not without the 20-year-old or the 12-year-old.
Law. As I'm reading the case law on child endangerment, it seems like in almost every case, there's an easily identifiable risk, a heightened risk that's created due to the particular activities of the parents, whether it's drug use in the home, using a butane torch to light hashish oil, putting kids in the back of a pickup truck with other junk and debris.
Walking into a child 2 years old wearing galoshes in the summertime, and you wonder, why is she wearing galoshes? Because there's raw chicken meat with maggots all over the house. Those are examples.
It seems like the cases, if you read them together, indicate very real risk or real possibility of risk means something that we can identify above and beyond just the normal risk of life. And that's kind of what you're talking about is, well, there could have been a fire, there could have been an abduction, there could have been this, siblings could have fought. I mean, that's true in every, well, I'll say it's true in my family. I'm not sure if it's true in every family, but those are just things that are normal incidents of life. And it seems like very real possibility means that the state needs to be able to identify at least one heightened risk that's just not speculation. That's kind of my issue with this, is the other cases are pretty easily distinguishable in my mind. So address that point maybe.
Responses to that, I think. The first, that the ones you're talking about, I think, are the easier cases. And I'd point this case to Smith from the 2016 from the Court of Appeals, where the child was left at the intersection outside the daycare, left unattended there, right? And you don't have to particularly, you can say that here are some things that could have happened. The child could have wandered into traffic, could have been abducted, could have, but you don't have to stake your hat on one of them. It's just generally a situation where there are known risks to the child, and the child is not equipped to navigate those situations on their own, and by putting them in that situation, you've created those risks. The other thing I'd say is, look, the jury we're not unique in having these lived experiences.
I mean, it seems like leaving a child at the intersection of a street is very different than leaving your children at home, in your house, when you have a standing agreement with your neighbor to help the children in the case of any circumstance. I think we could identify the risks of intersections, of being struck by traffic, et cetera. That seems very real. I'm not sure what the very real risk here is other than the risk of living.
I think it's more than that. It's risks inherent to the particular development and maturity of the children involved here, that there's relational issues, emotional.
I actually look at him differently. I mean, if you think that he is somewhat challenged in his ability to supervise, I actually look at him as being uber aware. My God, he called 911 because his sister got ticked off and left. I mean, he is on it. He is definitely paying attention to his environment. Did he overreact? Perhaps. And I thought the testimony was pretty good about the neighbor, that he kind of thought maybe he wasn't sure whether or not 911 needed to be called, but the kid was very focused. Couldn't it also be interpreted that he was Uber supervisor?
You could, but then at that point, he's out of his depth, that he's being asked to supervise essentially 3 other children.
As a former, a divorced father, I mean, all children are out of their depth. I mean, that's how you grow up. I mean, and how life works.
I'm sensitive to the idea that I don't think this statute is intended to criminalize a style of parenting, but let's just, to return to Justice McDermott's question, she tells a lie that she then later admits to when the police say, why are these children home alone? And
Bad fact for her, but it doesn't mean she's, yeah.
say that the 12-year-old is sufficiently mature and able, and I know that he is able to supervise these children. She doesn't say they had a phone and they could call me in case of an emergency.
Phone for a minute, Mr. Sullivan. I'm looking at 41 on the transcript, and on cross-examination, doesn't the officer acknowledge that actually the phone number for the mom came from the daughter?
Basically says if that's what the video shows, then that's what happened. But his original memory was that no, dispatch had to find it, and then
Cross-examination, he says, because I mean, I would think usually dispatch doesn't have a list of cell phone numbers handy. I mean, maybe they do.
Yeah, according to the transcript, she is actually the one who gave you her mom's number, isn't she? And the officer says, I believe so.
he's, led there by, and I see my time's expired if I can briefly answer. I think he's led there by representations that that's what the video shows. And his original memory, at which the state seemed to think was what the evidence showed, and we don't have any other evidence beyond his original memory untainted by leading questions and then the leading. And the jury gets to resolve that conflict in the evidence and say, I believe the account that he gave initially, and I reject as the product of leading and confrontation with the specter of, hey, if there's other evidence out there, is this what really happened?
That if this is the poster child of the kind of things that should be prosecuted where children are in danger, and I know for a fact the number of cases under 232.26C2, which is now something else because they renumbered them, but this, more or less have neglected a child. Every one of those, which is steroids compared to this one, in my opinion, they should be getting prosecuted? Is that the message that we want to send?
So I think that, and it's an important question, I agree. The question on review for this court is not the exercise of prosecutorial discretion and whether it was.
If we're supposed to look at substantial evidence, and that is the world that we live in, are all those cases that I'm talking about, that is examples of bad parenting, good parenting, whatever it may be. That is the ruler that we are using to measure. I mean, that's what we see. So when we're measuring and weighing the substantial evidence versus substantial risk, shouldn't we take those into consideration in our analysis?
So I do think that the court, when reviewing for substantial evidence and sufficiency, is bound. I mean, we do what the statute and the jury instructions say for the definition of the crime, and it doesn't particularly matter how many other, that's from Geddes. The question isn't how many other violations are out there. The question is whether this establishes a violation of the law as written and as instructed, and I think in this case that it does.
One question. Are you aware of cases from other jurisdictions involving these home alone type cases that are similar to this one where there was a conviction?
I know that they're cited in our Smith Court of Appeals case from 2016, especially one from West Virginia. There's, you talk about the idea of known, appreciable, and non-speculative risk. I know that just this December in Arizona, a man left his 5 kids to go holiday gift shopping for a matter of hours, and the house burned down and all 5 were killed. It's not the sort of thing that is out of left field to think that something could happen and these kids would need help and they might not be able to get it unless you put a child in charge who knows what to do, or you ensure that that there's a neighbor there who's able to help them, or that they have access to a phone.
Question. I'm sorry, Mr. Sloven. You're good at pulling rabbits out of your head. Very gifted lawyer. I mean, you've very, very gifted lawyer. But doesn't Ms. Newell raise a good point? There's risk if you bring the kids to the store. You've got 5 kids loaded into the car. It could be running around the parking lot because you're carrying the infant. and get hit by a car. I mean, don't you have to weigh, is that a greater risk than the risk of leaving them alone?
The statute says created a substantial risk. And so it has to be a risk that didn't exist and then your conduct gave rise to it. And then also I would say that this is one of the reasons why the jury, the collective community judgment of the jury is so important here, that, and there was kind of a hint at a necessity defense about I had to go to the store. It wasn't really raised as an affirmative defense here, but I think that's something that the jury considers is like, is this just an attendant risk of having children that every parent and every family faces?
Question. I understand your point about the jury kind of weighing relative risks, but I think our case law indicates that it has to be beyond mere speculation, right? So to this issue of whether she takes her children to the store or she leaves them at home, I mean, you could find, I'm sure very easily, actuarial tables and studies that talk about the risk per mile driven and the risk of people dying in house fires. And I had to guess, if I had to guess, the risk of dying in the car is probably greater than the risk of dying in a house fire, right? I mean, we don't know. But you're kind of acting as if leaving them at home is risky, but taking them to the store is risk-free. I'm not expecting the state to put on statistical evidence of risk of harm in these kinds of cases, but there should at least be something, I think, that indicates that this risk was great or real, or we could point to something. And I'm just not sure it's there. That's kind of my question on you. How do we evaluate those comparative risks?
About isn't the risk of being at home versus being in a car. It's the risk of being without supervision and without access to a phone if one's needed for emergency services. If they're with their mother who's supervising them, that defrays, right? The risk arises when they are left to their own devices to navigate their own situations, and they face particular barriers and dangers in doing so that happen to materialize in this case. And the officer spends 20 minutes with them waiting for her and gives his firsthand opinion of their maturity and their ability to be left alone without more supervision. And the jury could rely on that and could rely on the evidence of her statements to show that she knew that too. So I don't think that this is about actuarial tables here.
May I? Just to make sure I understand the state of the record, there was no evidence about the time leading up to when she left. In other words, specifically, that either she had in the past left them alone and harm had happened, or in the past she left them alone and no harm had happened, or maybe this was the first time. It's that the record is blank on that. Is that fair?
As that happened, the jury was, that they had been left alone previously, the jury's free to believe or disbelieve that testimony. And I mean, that's the thing about child endangerment, is that the actualization of risk is not an element, it's the creation of the risk itself. And so, especially when the argument becomes, well, she had left them alone previously and nothing bad had happened. Well, wasn't she creating a risk the first time that she did it then? If it was just anyway, and I think that especially when you consider that she didn't check with the neighbors, she didn't, the children didn't have a phone that they could use, that they could, at least the jury could conclude, and I think that's well supported by the record, that the children didn't have a phone as their first line of contingency against something bad happened that they could use to call her or call 911. But for the neighbor happening to be present opening the door.
You said
on the jury. They heard the evidence. They were free to waive this or agree with it or not. But that's also an opportunity for a judge at the end of the trial, jury NOV. And sometimes juries don't get it right, do they? Sometimes a judge has to say, and judges are loath to do that. But there are times when maybe the jury decision wasn't correct based on the evidence. Isn't that why we're here today?
So sufficiency of the evidence review should be for legal sufficiency, taking the evidence in the light most favorable to the verdict, drawing all reasonable inferences in support of it. And especially when, the danger is that this court will substitute its lived experience and common sense for the judgment of the community doing the same thing. It's okay to supplant, to apply our legal training, but it's not okay to replace our view of the world.
Question to you, where's the risk, the real risk, not pretend, speculative. I mean, because I've slammed my kids' fingers in the trunk of my car. I've done stupid things. I'm sure everybody around here, if we had to reveal what we've done, that's actually happened. Where is there some evidence? Justice May just asked about anything beforehand that made everybody kind of have a raised eyebrow. Where's the evidence, not just the what ifs? Where's the solid evidence that these kids were in danger?
Comes from her statements. It comes from the kind of conflict that actually happened, that prompted this. You know, she's headed off the property. The child in the 911 call reports that he had to intervene. Otherwise, that 9-year-old would have put hands on the 5-year-old in anger out of a fight that arose out of their leftover McDonald's, right? And it's not just, the state's not saying anytime you leave a 12-year-old in charge of any amount of other children that is child endangerment. The state is saying, under these circumstances, and in the view of the jury, well supported by the record, supported by Ms. Cole's own acknowledgement that she shouldn't have done what she did, that in this situation, leaving them alone, unsupervised, except for, with the 12-year-old asleep, the 10-year-old left with all those other kids, with all their conflict between them, that on this case did erupt, that could have escalated into a situation, very real and articulable risk that would escalate into a situation. And then if injured, there could be no one to call. No way to call anybody, nobody to turn to for support. Okay, thank you.
Thank you. I'd like to start by doing a couple of factual corrections. So the argument was between an 8-year-old and a 9-year-old, not a 5-year-old. There were quite a few kids in the mix here, but the 5-year-old apparently slept through all of this. In addition, part of the record is unclear about how far the 9-year-old went off the property, if she stayed near the front door of the apartment or if she went to the edge of the property. The record isn't clear. There was not a map admitted to help alleviate that clarity. And I would also like to say about the 10-year-old, if you've met one person with autism, you've met one person with autism. It is there are a myriad of traits that are associated with autism, how they present in each individual, in what ways and to varying degrees, and how those traits interact with each other is on a highly individual basis. Without additional information about the exact traits of his autism and how those presented, any information as to autism creating a substantial risk under these facts is purely speculative.
Maybe we went over this before, but there's been so much discussed. I want to make sure I understand your point of view. The state's pointing out that the mom does admit that she shouldn't have handled it this way. What do you make of that? Can't the jury sort of put some weight on that?
Context of where she made that statement is important in evaluating that. Ms. Cole made that statement to a DHS worker after she had already been arrested and was in jail. And what she simply said was, if I can pull that up, is that she wished that she hadn't left her kids alone. And that is not sufficient to meet the legal standard of knowledge of saying, I wish I hadn't left my kids alone because they always get into fights or because the 12-year-old always falls asleep. Simply making a statement of regret does not rise to the level of knowledge that would constitute child endangerment. I think it would have been very hard for her too, given the context that she has a 5 or 6 month old baby and not seeing that baby for about a week. I think that that's enough to say that that's not necessarily a question of guilt, but the context of that statement is important.
Use that on substantial evidence review, it's not our task to substitute our views for those of the jury. I think that's a correct statement. It's a very deferential standard of review. But instead, we have to look for legal insufficiency. So in that light, what is your best argument that this is legally insufficient, given that all the things that we're talking about were the same things that were argued to this jury?
I believe that this case is legally insufficient in light of the case law history under Iowa for child endangerment. The cases are typically divided up into a defendant committing illegal conduct or conduct where it's not per se illegal, but the risks are so obvious, or in other cases where a defendant intended the expected result. I think it comes back to the general intent requirement of cases. There's an inherent nexus where it has to be related or reasonably expected to follow from the conduct. The state mentioned State v. Swift about a 6-year-old boy being intentionally left outside for an hour and a half in December at dusk next to a busy intersection and was found under a car crying. The 6-year-old was expected to wait outside for an hour and a half. That's obviously a very different circumstance than what is left here. I think the case law is also clear that when a child is left in the safety of their own home, that's taken in a different light. Does that answer your question?
Following up on this area, I mean, it has to be substantial risk. And I think where Justice McDonald might be driving, and I'm interested in this too, is, I mean, substantial risk must mean something significantly above the ordinary risks of childhood. And is that what we're looking for?
It's helpful to think about it as not imaginary, that many of these risks are imaginary. There's no indication that this child was going to get abducted, or the state's arguments were completely inarticulate. Bad thing is not reasonably definite to give a criminal defendant knowledge of what would constitute child endangerment. I think looking at the facts in terms of, had there been specific additional facts alleged that would have said this was predictable, this had happened before, there was reason to believe it would happen again, I think there's a different circumstance between a parent leaving when the kids are in the middle of an argument versus leaving when 3 of the children are asleep, the 2 oldest ones get along, they're there, they're watching the kids, and she's got to get diapers. And so it should be something more than just living and childhood risks presented. I see that I'm out of time. We ask that you reverse and remand this case to the lower court for an entry of dismissal. Thank you.
State versus Cole is hereby submitted, and court is adjourned for the afternoon.